And this falls under our mantra, as I said, which I don't think is our mantra. There's no trademark pending over this. This should be everyone's mantra in the trust environment of read the deed. Factual scenario. We had a standard family trust. I'm sorry, when I say standard, I should put a little bit of an asterisk across there, where I've also got an asterisk down here. We thought it was standard. And certainly the accountants that had sent the job into us had been operating for about 10 years on the basis that it was a standard family trust. Under that trust, we had a principal. Well, they'll title it a principal. That can also be often referred to as an appointor. In other words, a person who had the right to hire and fire the trustee as their primary role. And many of you will be aware that for some trust instruments where there is a principal or an appointor, there is then under the power to vary, if there is a power to vary, there is then under the power to vary a requirement that that principal actually consent to any purported variation before going ahead to do the variation. Now, interestingly, and again, I think reinforcing from our perspective and the accountant's perspective who initially identified the issue, we thought that that further reinforced that this really was just a standard discretionary trust because the principal was not required to consent to any variation. There was then a variation that was done about 12 years ago before this accountant got involved. They'd only been working for the client for about 10 years, and that variation nominated a bucket company. So a corporate beneficiary managed the tax rate down at the 30 cents. Pretty standard strategy. As part of a review in updating the trust, and we were looking to do one of these other strategies in terms of starting to think about handing on the control, we, in conjunction with the accountant that let us help, actually sat down and read the trust instrument. And you just can't write this stuff. The second to last clause, buried inside some general powers about, the power to lend, the power to invest, the power to do whatever else, there was a clause that had a really nebulous or unexciting titles, which just was further provision, which again doesn't sort of give too much away. And the further provision says that in relation to any exercise of the power to vary, so we were in the loop with this variation from 12 years ago, in relation to any exercise of the power to vary that results in the nomination of a new beneficiary, so again, we're within the parameters still of this clause. We've exercised the power to vary. We nominated a new beneficiary. If you want to use that power, you must get the principal to consent before you go ahead and use the variation power. Pulled out the deed of variation, principal had not consented. We've got 12 years of distributions to this bucket company, and as we're sitting here today, every single one of those is void for the failure to comply with the trust instrument. Now, as I said, have we got a solution for that? No, we don't. Is there a prize for anyone that can cherish the solution? Absolutely there is. Our, with hindsight, solution is simply read the deed, read the deed, read the deed, read the deed.